Please welcome Professor Douglas Moll from the University of Houston Law School for a big picture discussion of corporate oppression principles and their application. This is Professor's second time presenting at the symposium. Professor Moll, the mic is yours.
Can you all hear me? Oh, there we go. Okay, sorry about that. Thank you very much for the introduction. I've been a law professor at the University of Houston since 1997, and much of my scholarship has focused on minority owner rights in closely held businesses and the related doctrine of shareholder oppression. And as I'm sure everybody who's here knows, Michigan has had an explosion of these oppression cases over the past several years, both in the corporation and in the LLC. And so I was very happy when last year Mark reached out to me to participate, and I wish I could be there again in person, but as we all know, that's sort of a little dicey these days. But I'm glad to be back to participate. My role here, as I understand it, is I want to go over some basics of the closely held corporation and the oppression doctrine so that we all have a common foundation to launch off from. And as part of that, I'd like to situate Michigan within sort of how I see the national landscape of oppression law and point out in a couple of places where I think Michigan is very different. So let's start a little bit.
Professor, you're on mute.
I was bragging about how I have taught from Zoom now for 2 semesters, and so I'm a complete Zoom master. And then, of course, this occurs. So please forgive the fact that I am not anywhere close to a Zoom master, and give me just one more moment to figure out very quickly, if I can, how to share my screen. So 1 second. Okay, I think I need to go to number 2. All right, is that better? Can you all see my slides? All right, well, God willing, you can see my slides. And if not, my guess is they're not that useful anyway. But at any rate, let's start with some background on what a closely held corporation is. As many of you are undoubtedly aware, a closely held corporation is a business organization. It is in fact a corporation, and it's typified by a small number of stockholders and the absence of a market for the company's stock and substantial shareholder participation in the management of the corporation. Now, if we were in a publicly held corporation, as most of us are aware, your typical shareholder is a passive investor. They don't contribute any labor to the corporation. They don't take part in any management responsibilities. Your basic shareholder in a public corporation invests money and hopes to receive a return on that money through dividends or sale of the company's stock at an appreciated value. But the closely held corporation is very different. In many, not all, but in many closely held corporations, the shareholders typically expect an active participatory role in the company, usually through employment, as well as a meaningful role in management. And of course, like all shareholders, your closely held corporation shareholder also invests money in at least many instances and hopes to receive a return on that money. But by definition, there's no market. There's no active market for the stock of a closely held corporation. And so any investment return is normally going to be provided by employment compensation and dividends rather than by sales of stock at an appreciated value. All right, so what's the problem? By the way, I put in all these PowerPoint transitions to delight you. I hope they are delighting you. They're probably just annoying you. So what's the problem? So the problem is we've got these conventional corporate law norms of majority rule and centralized control, and they can lead to some serious difficulties for minority investors in closely held corporations. Now, why is that? Well, traditionally, most corporate power is centralized in the hands of the board of directors, right? And so the directors will set policy and elect officers and supervise the operation of the corporation. And because directors are elected by shareholder vote, the board of a closely held corporation is typically controlled by the shareholder or shareholders who hold a majority of the voting power. And through this control of the board, a majority shareholder or a majority group can dictate, basically directly or indirectly, every aspect of the corporation's business. Now, of course, exercising control in a genuine effort to benefit the enterprise and its owners is perfectly legitimate, even if that effort necessarily prejudices minority owners to some extent. But as we all know, the power to control also encompasses the power to abuse. And whether that abuse springs from greed or spite or intergenerational conflicts or some other reason, the minority shareholder in a closely held corporation has no viable escape route. And when the majority decides to act in an abusive manner, those actions are usually designed to restrict or deny altogether the minority's financial and participatory rights. And we usually refer to those as freeze out or squeeze out actions that have the effect of oppressing a minority shareholder. And if God willing, you're seeing my slide, you can see on the slide some common oppressive tactics: terminating employment of minority owners, removing the minority from positions of management, denying dividends, denying information, siphoning off earnings. And I should mention, these are just examples. Many cases will say that a single oppressive action can be enough to establish oppression. But I should point out that in most cases, you tend to see more than one of these. I'm gesturing over here to where I see the slide. You tend to see more than one of these oppressive examples, and not just those, right? I mean, really anything that's unfair can constitute oppressive conduct. Now, in the public corporation, of course, if you're a minority shareholder, you can escape any abuse of power that you perceive by simply selling your shares on the market, right? But by definition, that market exit is not available in a closely held corporation. Now, we might care less about that, and we might care less about the need for an oppression doctrine, even though there's no market, if the minority shareholder could basically demand to be bought out, right? If there was a default buyout right in corporate law, we might not care about the oppression doctrine, because minority shareholders could get out. They would have an exit right. They could just demand, hey, buy me out now so I can recover my capital and move on down the road. But as most of us are probably aware, there is no state in this country that provides such a default buyout right. If you don't have a contracted for buyout provision in your shareholders agreement or in your organizational documents, your bylaws, your articles would be unusual, but I suppose you could have one there. If you don't have a contractual buyout right, you don't have a right as a shareholder to compel a redemption of your holdings. Now, we might not even care about that if it was easy for minority shareholders in a closely held corporation to dissolve the corporation, right? Because dissolution can also provide you with an exit. When we dissolve a company, we basically sell it, and we get as much money as we can. We pay off the creditors, and then the shareholders get whatever's left over. They get their proportionate share of anything that's left over. So that would be a way out if a minority shareholder had the right to compel dissolution. But in every state in this country, that right does not exist. In every state in this country, at a minimum, in order to compel dissolution, you have to own a majority of the company's stock, which by definition, the minority shareholder doesn't. And in most states, you also have to have a board of directors resolution. So the bottom line here is, if you're an oppressed minority shareholder, what I'm trying to convey is there really are no effective exit rights. And that's probably the biggest driver of how the oppression doctrine came to be, to remedy this problem of shareholders getting frozen out with no exit in a closely held corporation. All right, so let me say a quick word about how has sort of nationally, how has the law responded to what we might call this oppression problem? Well, I would tell you there's two significant avenues of relief for an oppressed shareholder in a closely held corporation. In some jurisdictions, that relief is legislative. And in other jurisdictions, the relief is purely court-made. And in some jurisdictions, the two avenues coexist. But let's start by talking about the legislative relief. On this slide here, it says the statutory action for oppression. So let's talk about this for a moment, because over the years, many state legislatures have amended their corporate judicial dissolution statute to include oppressive conduct by directors or those in control as a ground for involuntary dissolution of the corporation. And again, hopefully you can see the slide, but I would tell you that's about 40 states. About 40 states in this country have what I would call a dissolution for oppression statute. Now, most of those statutes leave it to the courts to define what the heck do we mean by oppressive conduct. Michigan does not, which we'll talk about in just a moment. But so the courts, generally speaking, nationally have had to come up with a common law definition. What's meant by oppressive conduct in these dissolution for oppression statutes? Now, this will be important to our discussion of Michigan in a moment. Most courts define oppression as conduct that frustrates a minority shareholder's reasonable expectations. And if you look at that first sort of darker bullet point there, this is a pretty conventional definition. It came from a well-known New York case called Kemp and Beatley. Oppression should be deemed to arise only when the majority's conduct substantially defeats the expectations that objectively viewed were both reasonable under the circumstances and central to the minority shareholder's decision to join the venture. Now, other states or courts, I should say, delineate oppression almost like just an unfairness standard. And so look at this second definition here. Burdensome, harsh, and wrongful conduct, a lack of probity and fair dealing in the affairs of a company to the prejudice of some of its members, or a visible departure from the standards of fair dealing and a violation of fair play on which every shareholder who entrusts his money to a company is entitled to rely. Now, of those approaches, again, I would tell you that reasonable expectations is the most widely used. It's been adopted by the highest court of several states, and it's generally favored by commentators. Now, as I mentioned, there's also jurisdictions that have judge-made relief, and it won't surprise you that that tends to arise in states which lack a dissolution for oppression statute. And so in some states, the courts have stepped in, and they have imposed a fiduciary duty running from shareholder to shareholder, a direct action that a shareholder can bring against another shareholder for breach of fiduciary duty. And the best known example of this approach is out of Massachusetts, a case called Donahue versus Rod Electrotype. And this sort of goes back to where Mark started us, back to Meinhard versus Salmon. Let me just read you a quick passage from that opinion. We hold, this is from the Donahue opinion, we hold that stockholders in the close corporation owe one another substantially the same fiduciary duty in the operation of the enterprise that partners owe to one another. Again, hearkening back to Meinhard. In our previous decisions, we have defined the standard of duty owed by partners to one another as the utmost good faith and loyalty. And I should point out that a number of states have followed Massachusetts' lead, and they've imposed this fiduciary duty running from shareholder to shareholder in a closely held corporation. Now, although this legislative remedy, this dissolution for oppression statute, and this judge-made remedy, this common law action for breach of fiduciary duty, technically they're two separate doctrinal approaches, but from the 20,000-foot view, they really each reflect the same underlying concern for the position of minority shareholders in closely held corporations. They're each ways of saying, we think special rules are needed to protect minority owners of closely held corporations. And so, yes, we should think of them as doctrinally separate, but again, from a general standpoint, they're basically jurisdictions saying we need to come up with some special rules because we think this freeze-out problem is a problem. All right, quick word about remedies. Let me just mention in most jurisdictions, the courts have the authority to offer a wide range of relief. And I mean relief short of dissolution. Dissolution is generally recognized as a drastic remedy. In jurisdictions that have a dissolution for oppression statute, the statute itself often provides the alternative remedies to dissolution, like Michigan, which we'll look at in a second. Even if the dissolution statute is silent on alternative remedies, most courts have found it to be part of their inherent equitable authority to grant remedies short of dissolution. In fact, most courts have rationale that goes something like this. The legislature gave us the power to kill the corporation, in other words, dissolve it. So surely we have the lesser included power to do something less drastic if we feel like that will solve the problem. Not surprisingly, in breach of fiduciary duty jurisdictions, since breach of fiduciary duty is generally seen as an equitable action, courts describe their authority in very, very broad terms. And my last point to you here is simply, these days, dissolution is an extremely rare remedy. What you typically see are these alternative remedies to dissolution. And I would tell you the most common alternative remedy today to dissolution is a buyout of the oppressed investors' holdings. And we'll talk more about that in a moment. All right, let me get over to Michigan. And by the way, I see you all chatting, and I know we have time for, oh, look at that one. That's my favorite, when the bird flies away. I know we have time after Professor Zach's for questions, so if you'll bear with me, I'll take a look at them as soon as I can. So let's talk about Michigan for a moment. So the Michigan has a dissolution for oppression statute. And the one we're looking at here on the screen is section 1489. And Michigan has an analogous LLC statute that's very similar. But let me just run through this very quickly. If you look there in paragraph 1, and I'm just going to paraphrase with the blue words here, a shareholder may bring an action, ... to establish that the acts of the directors or those in control of the corporation are illegal, that's one ground, fraudulent, that's a second ground, or willfully unfair and oppressive. So that is the third ground that we're obviously focusing on this evening. And notice that it says to the corporation or to the shareholder, which I want to spend some time chatting about. If you'll notice there, A, B, C, D, E, F, Michigan is one of those statutes that actually lists alternative remedies in the statute. So the court doesn't have to grant dissolution. The court can grant any relief, quote, as it considers appropriate. And this is just some examples. It's not an exclusive list. If you'll notice, E on there is a buyout remedy. It's explicitly a part of the Michigan statute. Subsection 2 basically says if you own stock in a publicly traded company, you can't use this statute. You already have a market exit. You don't need an oppression remedy. This is for closely held corporations, which by definition don't have a market. And subsection 3, which we'll talk about in a few moments, actually defines what's meant by willfully unfair and oppressive. Okay. Let me talk about a couple of things that jump out at me when I look at the Michigan statute and some Michigan case law and I compare it to national trends. Okay, this is sort of a list of, in the next 12 minutes or so, what I hope to get through. And so the first thing I want to talk about is that language we just saw about oppression to the corporation. And I think I blew that up again. So here, this first paragraph is that same subsection 1, a portion of it that we looked at a moment ago. And remember what it says, you can prove that there's the directors or those in control have acted willfully unfair and oppressive to the corporation or to the shareholder. Now, I will tell you that oppression to the corporation is an unusual concept because the oppression doctrine was not developed to address corporate harm. We already have derivative lawsuits for that. The oppression action developed to address harm to the individual shareholder. And just to try to bang this point home a little bit more, that language to the corporation that you see in Michigan is not present in most state statutes. I'll just give you an example. The New York dissolution for oppression statute says the directors or those in control of the corporation have been guilty of illegal, fraudulent, or oppressive actions toward the complaining shareholders. That's what you typically see. Now, when I was here last year, I learned that the Michigan oppression statute, the one we're looking at, actually derived from the South Carolina statute at the time. And I mean going back to, I believe it was 1970 approximately. And that South Carolina statute that Michigan borrowed their statute or derived their statute from did actually have that language, oppression to the corporation. And more interestingly, even the current South Carolina statute still has that language. And let's just take a look at that. It's on the slide and it's this bottom half. This is the current South Carolina statute. The directors or those in control of the corporation have acted, are acting, or will act in a manner that is illegal, fraudulent, oppressive, or unfairly prejudicial. So notice that it breaks up that ground, drops the willfully, which we'll talk about in a second, either to the corporation or to any shareholder. So you see that language again. And then it says, this is very important, whether in his capacity as a shareholder, director, or officer of the corporation. That's going to be very significant to us. Okay, now I have a theory about this language to the corporation, which you may feel totally free to reject. But if you recall, this statute also covers illegal conduct and fraudulent conduct. That is often conduct that harms the corporation. And my suspicion is that perhaps this language of to the corporation was meant to apply to those grounds and not necessarily to oppression. But regardless, whether you agree with my argument or not, it's definitely been the case that this language has been significant in Michigan judicial decisions. And let me just tee this up for a moment. Many jurisdictions confront the following problem. What happens if the directors or those in control do bad things that harm the corporation, and they only indirectly harm the minority shareholder because the shareholder is an owner of the corporation? In other words, assume with me that those in control do things that you would normally bring a derivative lawsuit to remedy. So for example, a conflict of interest transaction that's unfair to the corporation, or maybe the majority is using corporate assets for personal purposes. Can you bring a direct action as an individual shareholder? Can you bring a direct action for oppression based on harm to the corporation that is only indirectly to you? This is a hard question in a number of jurisdictions, but it's not hard in Michigan. There are Michigan cases that point to this language, oppression to the corporation, and say, yes, you can. The statute says that oppression to the corporation counts as oppression. So let me just say that in Michigan, this language makes the oppression cause of action much broader than you see in other jurisdictions, because it's not limited to a special injury to the minority shareholder itself. Okay, but in another sense, the oppression cause of action in Michigan is much narrower than you see in other jurisdictions. And let's chat about that for a moment. So let's look at, this is subsection 3 of the statute that we didn't really focus on a moment ago, but let's focus on it now. This first paragraph, the Michigan statute defines oppression. And look what it says: willfully unfair and oppressive conduct means a continuing course of conduct, or a significant action, or series of actions that substantially interferes with the interests of the shareholder as a shareholder. Now that language, as a shareholder, I would again tell you is unusual. In fact, I would say that language is diametrically opposed to most other jurisdictions that via statutes or case law explicitly indicate that oppression can be to a shareholder in his or her capacity as a shareholder, as an employee, or as a director. Again, just taking a look at the current South Carolina statute again here at the bottom, right? Look at that bolded language. South Carolina still has that to the corporation language, but it's added this parenthetical about your capacity as a shareholder, director, or officer of the corporation. Okay, now this language matters because, as many of you are aware, you've got case law in Michigan. Like the case that comes to my mind is that Franchino case, where the court said, look, we only protect you as a shareholder. And what the heck does that mean? Well, it means we're going to protect your traditional shareholder rights, things like dividends and voting rights and inspection rights. But employment's not a traditional shareholder right. And being a director is not a traditional shareholder right. In fact, in Franchino, the minority sued and alleged oppressive conduct based on his removal from the board and his termination from employment. And the Michigan Court of Appeals said, sorry, that doesn't affect your interest as a shareholder. And once again, I just want to emphasize, this is very, very different from other states that have case law indicating that terminations of employment and removals from management, denials of participatory rights, in other words, are very common grounds for oppression-based relief. Now, Michigan amended their oppression statute after Franchino. And if you look on the screen here, that second paragraph, notice what it says: willfully unfair and oppressive conduct may include the termination of employment or limitations on employment benefits to the extent that the actions interfere with distributions or other shareholder interests disproportionately as to the affected shareholder. Now let's talk about that for a moment. I don't think that provision builds back in protection for employment as a participatory right. But let me just explain this for a moment. It is true that there are a number of closely held corporations where employment is the vehicle for distributing profits of the firm. Now, why is that? Because the corporation can take a tax deduction if it characterizes a distribution of cash to shareholders as employment compensation, but it cannot take a deduction if it characterizes that distribution as a dividend. And of course, this is assuming we're not talking about S corporations. So in many corporations, this is really my point, the company has a tax incentive to pay out what really are dividends, but to disguise them as employment compensation so that the company can take a deduction. So if you're in a corporation like that, where all the profits get distributed as employment, if you get fired, that effectively results in an elimination of your ability to receive a financial return on investment. And so in that kind of situation, the Michigan statute does protect you, because employment there, when you get fired, that is interfering with distributions. But I'm not sure the language does anything if employment is merely a participatory interest and doesn't have this financial return on investment component. And let me just point out that there's nothing in there about protecting a position on the board of directors. A board seat is not an employment position. So in this sense, Michigan's oppression action and what it will protect is actually narrower than what you see in other jurisdictions, as it doesn't appear that participatory interests are protected for their own sake. And I happened to run across this case, MJC Ventures, Eastern District of Michigan, from this summer, June 30th of 2020. Let me just quote a little bit from the case. The court says, exclusion from corporate governance is not recognized as minority oppression under this statute. Corporate governance is not a shareholder right and therefore not actionable under Section 1489 by plaintiffs as a shareholder interest, nor does Section 1489 permit shareholders to recover for harm suffered in their capacity as employees or board members. So there you go, right? That's sort of the court making the narrower point that I was trying to make. Okay, very quickly, let me just wrap up these two other points. Oh, I'm already getting played out. Oh boy. Okay, so Michigan's got this definition of oppression in the statute. And let me just point out that that definition of oppression is its own. It's not reasonable expectations. It's not burdensome, harsh, and wrongful conduct. And so I sort of wonder in Michigan, is it difficult to look to precedents from other jurisdictions? Because it's always the case that someone can argue that Michigan has a different definition of oppression. Very last point. You all have this case, Franks versus Franks. And to establish oppression, you have to prove that the majority did the oppressive actions with the intent to substantially interfere with the shareholders' interests. And the court makes the point that if you can show you intended to act for a legitimate business purpose, then that's a defense to oppression. And I just want to raise the question of what happens with a mixed motive in Michigan, right? It's not always the case that people act with a solitary motive. If you act both to benefit the company, but also because you want to stick it to the minority shareholder, how does that work itself out given this Franks requirement? Okay, well, I only have 29 minutes according to my stopwatch, but because I'm getting played out and I don't want to walk all over my colleague here, let me stop there. I'll take a look at the chat and we can hopefully discuss some more during questions and answers.